Good evening or good morning for some others. Good afternoon, everyone, for this new round table on a new round, which is quite strange. Too many new rounds, but indeed, the pressure is really high. It's since many years, since 2012, where a lot of new domain extensions were added, and since then, yeah, the market was really in demand to have this, and this will be launched pretty soon. Tomorrow, not sure, 1st of April, huh? Be careful, but for sure in April it will start. So what it is about, I will just introduce briefly the news about the gTLD. It's not just the new top-level domain and generic, it's much more than that. And just to give you a few highlights, there are about 9 different types of generic top-level domain names. You have blocked that we cannot use, we have some reserved, that's for the Red Cross and Olympic Committee and things like that. And there are different other types of brands. I will take just an example. The city close to me is Waterloo. There was a famous battle there, and maybe we will have a battle for the Waterloo. That's possibly because there is not only one Waterloo in the world. There are 128 Waterloo in the world. Who has the legitimacy to use the name Waterloo? Good question. And maybe it's not a place. It could be also a brand. We have Waterloo beer, we have whiskey Waterloo, we have sparkling water Waterloo, we have bathroom Waterloo. There are a lot of brands with the name Waterloo. Who is legitimate to have the name? And it's not an easy question, not an easy answer. Also communities. We have also the Waterloo Connections, and Waterloo Connection is really the community of all Waterloo and communities using the Waterloo name in the world. Unfortunately, they don't have much money for these Waterloo connections. So this is the kind of topic we will see tonight. I just highlighted 3 different top-level domains: the brand, geographical names, and the communities. And it's not only that in the program. There are more than 400 pages just for the applicant guidebook. It's more than 400 pages. That's only the emergent part of the iceberg. It's a huge work behind. That's also why the cost, if you want to apply for a new generic top-level domain, is 227,000 of US dollar. That's really an incredible amount of money. And that's also why that's a big improvement to have the applicant support program that was opened. About 40 were expected, but we had 74 organizations or communities coming with this applicant program to have a rebate between 75% and 85% rebate on the amount to be paid. So that's just the baseline, because there are also many other extensions. If there are conflicts with different brands and legal names, we have more talk about this now. And we gain a lot in terms of maturity with this new round compared to the previous one. The team made an incredible work by having a lot of process, foreseen many things. I'll just give a few examples. There is now a clear split between the technical side and the applicant side. And we have someone here to talk about from LEMARIT about the technical side. So really the gTLD, you have now RSP, so really the service providers on the technical side, they can really be there and be assessed separately than compared to the applicants. There are also much more characters that you can use in line with the universal acceptance. 27 different alphabets are now supported. Arabic, I just name a few, Chinese, Han, Ethiopic, Hebrew, Japanese, many of those, 27 different alphabets, and not only from left to right. That's really a big challenge. So many new things came also with procedures on how to manage the different conflicts and that could appear, how to give priority to one or to the other, how to manage the different risks. And it's really a clear process. We start in April for a duration about 12 to 15 weeks. And afterwards, after the whole evaluation period will start for 8 weeks, and we'll have a reveal day. What are the different new names proposed by the community, by the brands, by the geographic will be then publicly known, with then 2 weeks afterwards to let the possibility to some to change and use an alternative name that they have submitted in their application. So that's the string confirmation day. And then there is the process will continue with the GAC, with the whole community about, okay, what is the feedback on those new top-level domain names? Because it's so important when it is there Yeah, it is there. There are also questions coming from Quebec. What do we do with there is already an existing .Quebec and there is Quebec with an accent that's relating their critics. Not ready yet. It will be ready by the end of the summer and its implementation expected mid next year if ready. But the important is to understand that this program is really a huge program and it will not be just roll out and executed in 1 year. ICANN is expecting to roll out this program and this will take several years, even to 2030, from what I've read in some papers. That's really the point. We'll have some auctions also. If there is competition between one Disney and one Disney, there will be auctions. And the money from the auctions will be taken back also for the support program. So people having less money, they will be funded thanks to this auction. That's really the mechanism behind. That's also why the exact percentage is not yet defined. 12 has been pre-approved, but about 60 are still needs to be studied. So that's in a nutshell, just to give you an overview that it's not just a new domain name extensions of top-level domain. There are many things behind, and we'll have plenty of speakers. Unfortunately, Emilia Ska is sick today, so we will not have her. We try to cover the different topics in different way during this meeting. And I will give now the floor. I'm not sure if we have. So we have Olivier Crepin-Leblond first. I just introduced him. He's a co-chair of the at-large Consolidated Policy Working Group, which is really the big Consolidated Policy Working Group talking about everything and from the at-large community.
Thank you. I'm just going to take 5 minutes to take you through the lessons from 2012, the last round of new gTLDs, when we were told it's all a matter of consumer choice, it's all a matter of trust, it's all a matter that people should be able to register the domain names that they want. I guess that end users are different from the rest of the ICANN communities in that end users are, I would say, there's two types of end users. There's the end users that have registered domain names, and they are, of course, directly then impacted as domain name registrants with the policies of ICANN and with the rounds, etc. And they perhaps are considering also registering domain names for their businesses, for their clubs and societies, for their private means. There are also those end users that don't have a domain name, that just use the internet, and their sole contact with the domain name world is by typing the domain name or on their browser or sending an email to someone at the domain name and so on. So knowing that we have these two, it makes it a bit difficult for a typical at-large view, because I guess some at-large might say that we want more domain names because we want to have more choice in our ability to register our businesses or our clubs and societies when there was only a small number of domain names, of top-level domains you could register them in. Most of the names were taken, and you would have to pay an atrocious premium for the name that you wanted. Of course, the 2012 round eased that and created a whole set of new top-level domains under which people could register domains. And I guess that the end users did make use of that. I'm not sure whether it was as much as we thought it was going to be the case, but certainly you can now see domain names and websites and email addresses that use all sorts of extensions. One of the big concerns that one had was that you could see a .com, a .org, a .net, and you'd say, oh, that's an email address, that's a valid domain name. And we felt that there could be some confusion with people using the internet and not recognizing the domain names. I'm not quite so sure whether that actually has happened or not, whether user confusion has happened. But one thing which has certainly happened is that there is more choice for people to register their domain name in. That being said, there were still a lot of shortfalls. One, for example, is the multilingual and script diversity. Very few applications were in non-Latin scripts, IDNs. And here I'm talking about non-Latin scripts, IDN gTLDs. I'm well aware that there's also a Latin script IDN now. But users in Arabic and Chinese and other communities can navigate things in their own script. And this was something which wasn't really around before 2012. And now, of course, we've got all these rules that are done. So it's hoped that there will be a lot of new top-level domains in these scripts. There's also greater community relevance. gTLDs appear to have been quite successful in some way, depends how you define success, but they certainly are being used. And that has opened the door for a whole range of new geographic TLDs that hopefully will be applied for in the next round. There are also a huge number of new safeguards that have been added since the last round in 2012. There's the RDRS, and there's the enhanced registry and registrar agreements. The auction proceed funds have been used in all sorts of ways to help out with some of the issues that we found. Some of the auction proceeds have been used for projects which have actually contributed to reduce DNS abuse, etc. And so there are more safeguards than there were in the previous round. And then, of course, more TLD choices make for a wider market, and there's a pricing pressure. We certainly are seeing that the price of domain names has gone down since 2012 quite dramatically, and we're not quite sure whether it will go down even further, whether it's even required. But certainly there's more choice for end users. Next slide, please. So there are still some concerns. The issue of DNS abuse is something that in at large we're very big on. And there has been, of course, a lot of work done to track DNS abuse, but it's still unresolved. I'm not sure if you can resolve it fully. Like any crime, you're always going to get a certain level of crime taking place. But what's good to see is that there are significant things that have been done to reduce DNS abuse, and certainly the industry has taken this very seriously. There's, of course, still the big question regarding who is and RDAP and the privacy and accountability, with some end users wishing to have more details about the owner or the registrant of a domain name, but others showing the GDPR and the fact that who is pretty much closed down, so on. There is no who is anymore. There's only RDAP now, exactly as Maxim Alzoba said. Yes, thank you. And yet there's still not very much information being given in these systems, because we still have some work to do. And there's still some consumer confusion, in quotes. If we're going to have more top-level domains, how can one find out legitimate and malicious TLDs? I think that malicious TLDs, you can't really qualify any malicious TLDs as such, at least with the checks and balances that ICANN subjects any applicants to. Hopefully there's not going to be malicious top-level domains, but it's more malicious domains under some TLDs, because some top-level domain registries do not police their space particularly strongly. So you'll end up with a higher amount of DNS abuse on there. So the verdict, I guess, there's certainly some partial progress. The world hasn't transformed completely. And I think that the 2026 round is addressing some of the 2012 failures, certainly the points that I've made here. But the big question is, are the end users the primary stakeholder in this whole thing? And in the last round, we found a lot of speculative applicants playing around and trying to drive the namespace, domain name investors, as they would be called. And I'm not sure whether that will be addressed on this round. That's one of the big questions that I have. The DNS will be growing bigger. I don't think having more top-level domains will make it any safer, but there certainly is hope, because, for one, community applicants have more of a chance to apply, maybe on this occasion, especially because we have seen the figures for applicant support, and there are a lot more applications that are being helped with applicant support. So I think that's pretty much on an end-user perspective. If our communities and if some of the at-large structures in our community are able to push forward for their domain name, for their top-level domain, then great. That's pretty much it. Thank you.
Thank you, Olivier, for this presentation. We would like this meeting to be interactive and to have interaction after each topic. And for this, we have as moderator Natalia Philippe.
Thank you very much. So my name is Natalia Filina, and yes, I would love to be a moderator of the discussion. Thanks a lot, and thank you, Frederic and Olivier, for your introduction. When I started to prepare the agenda of our discussion for today, I received some comments from the community members and colleagues that they said that, Natalia, so your agenda looks like not so positive view the new round of gTLD, and I did my best for improve it. And Olivier, thanks again for adding the concerns to the discussion, but we also have positive hopes, and we are working a lot, and all of our efforts will, I think, will help to shape this space for the new round. Now, so I would love to tell that all of our attendees may ask questions and provide comments in chat as well to have a tiny microphone. And I see Maciek, please take the floor, but for a few minutes only, okay?
Hello, I'm Maciek Piasecki. I'm a member of EURALO and a fellow for Seville. Before I joined ICANN, before I got engaged, I knew about the whole discussion about .amazon because that erupted way past what were any internal discussions. I was wondering if in recent years there was any other kind of discussion of this magnitude or of probably lesser magnitude, but like also one that was controversial in any way, and especially one that's related to users. And my second question would be, what are the processes where there's an established brand that already holds a domain name under numerous gTLDs, and those new gTLDs come in? Is there some special process? And I think that's also important from the user's perspective, as the users might get confused when there's, let's say, coca-cola.com and then coca-cola.lol comes in. Yeah, thank you.
Maciek,
Yeah,
thank you
thanks.
very much. So I think you will have answers and response from our speakers after. And if someone would love to provide an answer now in the chat, it will be great. Then we will have a time. Yeah, Olivier, please go ahead.
I was just going to say very quickly, Natalia, on the Amazon case, there have been a lot of other issues with other applications, but there is one thing now which has been brought forward this time. There is a second name. If you can't get the first name that you want, there is a second name, like a backup sort of name that you can fall back to if there is a big issue with the main name. The issue on .amazon is just incredible because you've got such a large firm here. They could have done an out-of-court settlement or something with the communities of the Amazon, but one of these things where sometimes you just wonder why they didn't. At the end, I think they did reach an agreement. It took quite some time. On the trademarks and on the brand TLDs, there are likely to be quite a few brand top-level domains. And yes, there are some brands that have domain names already under other top-level domains. The Trademark Clearinghouse is there for that. The Trademark Clearinghouse, when you register a domain name, will actually tell you, warning, this is registered as a trademark under other top-level domains. I think it does that now. Maybe it might have changed a bit, but back when we put that together many years ago, that's what it was doing. Thanks.
Thank you very much, Olivier. And again, so if we will have a time after the speakers, we will start this discussion again. Thank you, Maciek, for your question. Our next speaker is Jan Janssen. So Jan, you are a dispute resolution and intellectual property lawyer at PETILLION. And so we discussed the possibility to have this talk, I think, at Dublin. And now we are here, and I am very happy to meet you. So tell us, please, what happens and what will happen with the new gTLDs in case of illegal use of trademarks.
Thank you, Natalia. I will first comment on what Malik was saying a little bit further, because when a .brand is applied for by a non-brand holder, there's also a process that the brand holder can object through a legal rights objection, which will be administered by WIPO. And WIPO is quite relevant for the topic, and it's an interesting topic, and the UDRP, URS, and trademark claims, whether they are trust tools for users or entry barriers. And WIPO has been instrumental in the creation of the UDRP. But UDRP is something that deals with the abuse of trademarks at the second level, so at the domain name level, so before the gTLD. And the topic can be approached from various angles. Is it an entry barrier for a new registry to apply for a new gTLD? Or would it be an entry barrier for a registrant to say, I am not going to register a domain name because there is a risk of the UDRP or of other proceedings? Just here in the first line, reminded everybody of ICANN's mission and purpose, which is to ensure competition and open entry, but also to make sure that the internet and the domain name system is stable and secure. This links to what Olivier was presenting, like you need to have an open as a consumer choice, but also trust in the domain name system. And I think that the mechanisms that we're about to discuss have contributed in many ways to the trust of the internet naming system, because unfortunately most of these systems are after the fact, so some abuse may have taken place already, but they offer efficient mechanisms to address abuse, and in that way they may also function as a deterrent. So what are the systems that are within the ICANN sphere? And we have the UDRPs, Uniform Dispute Resolution Policy, the URS, which was developed in the 2012 round, which stands for Uniform Rapid Suspension. And then we have, Olivier already mentioned, the Trademark Clearinghouse, which is responsible for verifying trademarks and then making sure that the launch processes of a new gTLD occur in a decent fashion with respect for trademark rights. And there are some other policies. When looking at the UDRP, I think it's important to look to the history of it. And the UDRP is a policy that dates back to 1999. I don't know if everybody here knows, but ICANN was created in the end of 1998. So it was a very early policy, but it was a policy that was there to address issues that needed to be addressed and that were made clear in the white paper by the US government when that led to the selection of a new company, which became ICANN. What was the issue? It was that before the creation of ICANN, the company Network Solutions was administering all gTLDs at a time. And there were some users who had registered names that were identical to trademarks, and some of the brand holders didn't know of the internet before in the early days of the domain name system. And it was difficult for these trademark holders because they saw their trademark rights being violated, and those are internationally recognized rights through the TRIPS agreement and various other international agreements, and also considered a human right. It was difficult for these trademark holders to know where to act and on what legal basis to act. Most jurisdictions allowed for a certain use of the trademark to stop, but that didn't mean that they could acquire the domain name. So in this respect, UDRP was created, and one of the tremendous inventions of the UDRP is that there is a consensus policy that needs to be respected by every registry, by every registrar, and that there is jurisdictional clause that whenever a UDRP reaches its decision, there is a jurisdiction clause that can be either the place of the registrant or the place of the registrar, where after the out-of-court proceedings, there can be jurisdiction to assess the administrative decision by the dispute resolution provider. And that is something very interesting because it takes away a lot of the legal uncertainty that was there before, legal uncertainty that existed not only for the trademark owner who wanted to enforce its rights, but also for the end user who might have been confronted with a UDRP decision that they knew where the trademark owner will act, is able to act, and where he can defend himself. And that is something that could influence the registrar of choice or the place from which a registrant is operating. There's way too much detail, I think, in these slides, so we can move to the next slide. But I think this is really important background for the topic and the reasons behind UDRP. UDRP is a system that evolved. There was only one dispute resolution provider, that was WIPO, and WIPO, the World Intellectual Property Organization, was instrumental in the creation of the UDRP, was the first body to administer administer disputes under the UDRP. But we see that there are 5 other dispute service providers who administer the disputes and select panelists to judge. These are the steps within a UDRP procedure. I don't think it's important for the question whether it is an entry barrier. We see that the proceedings are very well structured and they run smoothly. Within 75 days, normally you reach a decision. The conditions, and maybe that is important. And what does a trademark owner need to prove? First, that he has rights in a trademark and that the domain name is either identical or confusingly similar to the trademark or service mark that is being invoked. Then secondly, the registrant may not have rights or legitimate interest in the domain name at issue. And third, the domain name needs to be registered and being used in bad faith. This end requirement is sometimes a burden for trademark owners because sometimes a domain name is not used by the registrant at all. And when you want to develop a brand, this can be an entry barrier for that trademark owner to really have its brand on the internet and in the gTLD system as well. I think that's the reason why the UDRP has been a model for many CCTLDs, country code top-level domain names, where the end requirement is not an end requirement, but an or requirement. And so where there's a bit more flexibility, notably in the .eu CCTLD, the end requirement is not only here transformed in an or requirement, but also it is sufficient in the .eu that you prove that the registrant has no legitimate rights or interest in the domain name for the domain name to be transferred. So it's a double or there. We can move to the next slide, please. Yeah, I think the standard of proof that is not relevant for this, so we can directly move to the next slide. This is what I said, and a decision is almost automatically enforced, but there is a 10-day waiting period, and within these 10 days, a court case remains possible. And where that court case can take place, that is something that is clear as from the outset. It's either the place of the registrant or the place of the registrar. The UDRP is quite an old policy. The GAC has been asking that this policy be reviewed, but the GNSO has not yet come to that review. And that is why one of the reasons why WIPO, together with the Internet Commerce Association, which I think is an association that really has the end user in mind, they came together and they created a project team of industry leaders and experts to do a review outside and independent from ICANN. And they wanted to identify best practices and look where there might be room for improvement. They issued the first initial report, which was open to public comment, and end of 2025 in December, they came up with their final report, which has some recommendations, some practical recommendations that are very that had consensus and that can be implemented quite easily, even without the need for a policy change. Then there are other suggested changes in that review, which had unanimity within the project team of expert leaders, but where further community discussion may be necessary for it to be resolved and policy changes. And then finally, there were agreements in principles on a number of items where really further debate and further directional work will be required. If we can move to the next slide. Then I think I've said that the UDRP is a mechanism that takes about 75 days from the complaint to conclude. In the previous round in 2012 and in the process leading up to it, the URS was developed to say, okay, there can be some very clear-cut slam-dunk cases where it should be possible to move even faster. And that is where they invented the uniform rapid suspension, which does not allow for a domain name that is being disputed to be transferred, but being suspended. If a domain name is suspended, it will refer to a standard page saying that the domain name has been suspended because it was in violation of somebody's trademark rights and the way it had been used. And so it can no longer resolve at that time. It is a bit less popular than the UDRP. Although it's faster, it doesn't give full control over the domain name. And in many cases, the interest of the trademark owner is to acquire the domain name. The duration, as I said, it's much shorter. It's less than a month to conclude. And there is a limited loser pays model that is really when there is a repeat infringer that has more than 15 domain names registered in bad faith. In those cases, they may come after you to contribute to the costs of the URS proceedings. We can move to the next slide, please. The sunrise in trademark claims, it's in association with this that the Trademark Clearinghouse was created. And as I said earlier, the Trademark Clearinghouse is going to validate the rights of a trademark owner and give 2 or, if you want, 3 services associated to it. The first service is a sunrise phase that during a sunrise, that is the early days of, and that is a pre-launch phase of a new gTLD, that within a short window of time, usually 60 days, only trademark owners can register domain names in that registry. For those trademark owners to be able to do their trademark rights need to be validated, and that's where the Trademark Clearinghouse comes in. After the sunrise phase, there will also be a trademark claim service. Trademark claim service will notify the potential registrant, like, hey, somebody has a trademark in the domain name that you're trying to register. Are you sure that you want to register this domain name? Because you could put yourself in jeopardy of violating somebody else's rights. The registrant then still has a possibility to register the name, but at least he's been made aware of the risk of it. And it can be perfectly possible that the registrant has a legitimate interest in a name that happens to be also associated to a trademark, but that the use is not at all linked to the trademark. But the trademark claim service is something that makes you consider this issue. And yes, it is an entry barrier maybe, but it is mostly a tool that makes users very aware of the rights of third parties, of trademark owners. And I think it is a tool that really contributes to building more trust in the new gTLD system. And I think that was my final slide.
Jan, thank you very much. If someone have questions or comments, or maybe Jan may answer the comment from Maxim Alzoba about some kind of updating UDRP.
Updates, what will need to happen in my view, and I think the GAC has been quite vocal on that issue also at the latest meeting in Mumbai, is that it is good practice for any policy, for even if the majority of the internet community is convinced that it's working well, it's a policy the registrars are happy about it, the registries are happy about it, because it takes a lot of legal risks that would otherwise be with the registry in running their registry, with the registrars in running their business. It takes a lot of risks away from them, and it creates a trusted dispute resolution process. But every process needs to be reviewed from time to time. I think WIPO and the Internet Commerce Association have done a great job in collecting experts and in jumpstarting this long overdue review. Yes, I think it is it is something that is likely to be done within the foreseeable future, that this review will take place at the GNSO level as well. Yes.
Thank you very much, Jan. So now I think I need to be careful with our timing, and I think we will have a time after all speakers. I would love to invite to the microphone Martin Kuechenthal, CEO LEMARIT. So Martin, I'm very glad to meet you tonight, and I'm not a master in this field, but I would love to ask you to do this to create some kind of interesting combination of knowledge for our participants about what happened to .com in new round of gTLD, and maybe this new round will change the economy of the industry and domain space, and maybe the format of competition, which always makes the life of customers and end users more vibrant. So please take the floor.
I bring a little bit different perspective to the panel tonight. My company is involved in ICANN for quite some time. We are corporate domain registrar, ICANN accredited. We have customers mainly in Europe, but also in the rest of the world. We are also a registry service provider for the next round of TLDs. We just successfully went through the pre-evaluation program with ICANN, and we still are serving also .brands from the first round and expecting also customers for S.brands for the next round of TLDs. When we were preparing this session or this panel tonight, I was thinking, what can I bring to the table? And it's the first thing is that as a corporate domain registrar, and I'm very happy for what Jan was into, because we are a heavy user of the UDP to reduce consumer confusion and to build up consumer trust, especially when our customers deal with sensitive matters, with sensitive goods or expensive goods. We are helping them to go through the process, to run the UDP and to stop the abusive use of these domain names. We just a month ago or so had one case with more than 200 or almost 200 domain names where one customer was attacked, which we achieved positively with the UDP procedure. So I can support that the UDP is a great possibility for brand owners to go against abusive domain name registration, and it works. So thank you for that. What do we expect and what can consumers expect in the next round? What I expect and what we in the analysis of the upcoming potential new TLDs expect is that we will have additional new generic TLDs. We do not expect too many of those, but maybe we're surprised. But I think there will be additional TLDs in the English-speaking namespace, but we also expect generic TLDs with one of the non-ASCII languages, which could be a benefit for the users in the specific areas. The question is, and I disagree a little bit with Olivier about the pricing. Yes, after the first round of TLDs, we could see that we have a massive drop in the pricing, but over the past years, we as a registrar see that the wholesale price of domain names is constantly increasing. And we can also see that domain names which have a very low price, and this is still have a very low price, have a problem with abusive domain name registrations. But in general, we see that domain name prices are increasing. And it will be interesting to see how the business models for the next round of TLD would look like. I personally don't think that the pricing will drop, because otherwise there is actually no business model. Of course, there will be high availability for new domain name registrations on the left of the dot when we have new TLDs on the right side of the dot. But there's still so many TLDs from the first round which have not been really accepted by the users. And it will be interesting how many players will take a bet on additional new TLDs in the next round. And new choices are not necessarily also better choices. So I think we can also expect a certain degree of additional confusion in the next round. I think especially new players in the market with new generic top-level domains, they will need to have a concept which users also will need and will also understand. So this will be a very interesting situation. But I personally do not expect too many new generic TLDs in the next round. Then what we can expect, and these players have already been positioning themselves in the market, is that from this Web3 area, domain names which are not in the DNS as we know it, that they will apply for TLDs within the ICANN space to connect them to their Web3 domain name space. Let me call it very simple. And this is an interesting model to get connected to these two worlds, maybe also to make this space, this Web3 space, a little bit more trustful, because there's no regulation and something like an UDRP is not existing in this world. That will be very interesting. There have been announcements from a couple of entities that they will apply for a quite high number of TLDs in the next round, which will cover their TLDs in the Web3 space. There can be also this cryptocurrency issue and wallets and all these kind of things involved. I think consumers have to be very careful also to understand what they're doing when they buy a domain name, which is related to Web3 domain names. We will have also, for sure, additional regional or city TLDs, because we have some very nice and very good examples from the past. And I think also we talked about that before. It's not about the numbers, it's about the usage. And when we have cities with a couple of 10,000 domain names and registered under their TLD, in a normal domain under management perspective, this would not maybe deemed successful. But when these domain names are used and build trust in their community, they can, from the perspective of the registry, still be deemed very successful. And we can also see these type of domain names, they are far away in the pricing from regular domain names, from generic domain names, because people pay extra for the regional trust, I would call it. And then we have the .brands topic, which I will spend some more minutes on. So what's the benefits of a .brand? And of course, due to the nature of my business, I have a look on that from a corporate standpoint, but actually the corporate standpoint is always also taking into account the consumers and the users' standpoint. And when you look at the benefits of a .brand from a legal and marketing perspective, then it's the branding part. You can really build trust with and for customers, because owning a .brand is just the beginning. What is needed in the development of a .brand is definitely to communicate that only where .brand or only a domain name which ends on the .brand, on the brand of this company, there will be trustful content. Because the big problem we have, and that is why UDRP exists today, and it's the structure of how this works. Everyone can register a domain name which consists or which has a brand in it on the left side of the dot. And the big difference between a domain name registration under .com or other TLDs and the .brand is only the entity, only the brand owner can really register a domain name under this .brand. So this is a built-in customer trust tool, and we can also see that is the reason why corporations want to apply for a .brand in the next round. You can also have an extensive use of the domain names, because you can register more or less. There are limitations, but in general, more or less all the domain names you want on the left of the dot. You don't have to pay premium prices. You don't have to buy domain names from third parties. You can register whatever you want, and you can also register when you want. So you have no time or no need of time before the registration. You can just do it in time, in the moment where you need the domain name. And that is very different to the registration of another domain name. You have a maximum availability. You can be really creative in your naming, or in the way of how to name your domain names. And you can optimize by this also your communications, very specific, very targeted. And you can also use your .brand to shape a direct regional access. We personally also believe that the use of a .brand will have an increased SEO advantage, but it's not the .brand by itself. It will also be and always be the content which is behind the domain name under the .brand, of course. And what we expect also for the next generation of searches is that AI agents, will also rely on content which is connected to .brand domain name registrations, because that must be the most reliable source. The benefits of a .brand from the IT perspective, or mainly the IT security perspective, that what we see in the next round or in the upcoming round of TLDs is a big difference between the reason why to apply for a .brand in the first place. In 2012, it was mainly, a fear of missing out. It was defensive applications for the TLDs. Nobody knew how many applications will there be, and there was not a killer application for a .brand, and it was mainly defensive. Mostly the legal departments have been involved to make these registrations possible. And what we see today is, due to the evolving threats in the internet, that the usage of a .brand can be not only for the corporation or for the brand owner itself, but also for the users, a good way to circumvent increasing problems in the domain name space. Because you have a total control over the entire namespace left of your .brand, so nobody can register domain names. The big difference between owning a domain under .com or others is there you're just the registrant, and here you are actually a part of the internet infrastructure. You own your own piece of the internet infrastructure. You can reduce attack vectors. For example, only one registrar is needed. There are no resellers, there are no public registrations. And also from a brand protection perspective, you can concise the URLs and use vanity URLs under your .brand. You can control much better spam and phishing, also because you can prevent homographic attacks. You can implement DMARC. There's no SEO fraud on a .brand. There's no email spam on a .brand. And this is also in the interest of the consumer and user. And of course, the trust and authentication, because whenever you see a domain name which ends or an email which uses a .brand, you can be 100% sure that this is from connected to the brand or to the corporation behind. And this is not only for the consumers and customers, it's also for the employees, the suppliers, and other contacts around the world. And then we have a technical difference here. You can, when you own your own TLD, you can already enable HSTS on the root level. That means HTTPS, so SSL certificates are required for all domain name registrations. This can also be a way of increased trust in the domain name. And of course, also DNSSEC implementation can be required on all domain names under your .brand. So this should have given you a short overview how we see the situation of the .brands and also the advantages for the user for the next round. I think I have one small example to show you. Within ICANN, I'm in the board of directors of the brand registry group, which is part of the registry stakeholder group. And one of my friends and colleagues within the brand registry group is Nisha Parkash from .sky. And she's a heavy user of the .sky TLD. And this is just one example. And in the past years, this has been a driver of trust building for the customers within Sky, because they have a very high level of trust built with the .sky domain names towards their customers. Emails in future or today are only sent from a .sky domain name. There are a lot of examples out there, and when you want to have some more examples in the wild, please contact me afterwards. I'm sure that there are not so many in this group of attendees who maybe want to apply for a .brand, but whenever somebody is thinking about that, it's now the time of the decision making to develop a strategic plan and to develop at least a rough business case. What do I want to do with that? To find the stakeholders within the organization, to find a way to get this through within the organization in regards of the application. And we think this program, and I think in the beginning Frederick was into it, it's a 400 pages applicant guidebook which you have to control and to understand for your application. And it's a good idea to find help to go through the application process, that you don't miss it, because who knows if there will be ever a next chance of applying for a new TLD. And for those who are interested in the .brand space, I would recommend also to join the brand registry group. It's a group of .brands within ICANN who are specialized in helping also new brands to get through the application process in the next round. That was it from me. I hope that this can contribute to the following discussion. And whenever you have questions about these topics, just write an email or see me on one of the ICANN meetings in the future. And yeah, thanks for now.
Martin, thank you very much. And be sure that inside of this group of attendees of this call, or from people who will listen to the recording, definitely we will have a lot of participants who will take your advice and tips. Thank you very much. And I'm very happy for this talk today, just because it's a little bit unexpected for what we usually having inside of our community, just because we are usually talking only about end users' interest. But of course, I agree with you. The success of the next round of gTLD will be measured not with the number of new extensions, but the practical utility, trustworthiness, and simplicity. And so we would love to see this, yes. And we would love to improve our end users' digital life. Now we will come close to the topic about trust, security, abuse rates in new gTLD. And we know that user perceptions is heavily influenced by DNS abuse levels. And the extension with the weak enforcement quickly lose credibility. And Maxim Alzoba, I would love to invite you to the microphone. You are special project manager, International Relations Department, FAITID, but as well you're counselor for GNSO. Yes, understand. Not now, yes, in previous years. Former, okay, so maybe future one. So please tell us about what is the range of possible action of DNS actors in and after new round of gTLD.
Thank you. I'll speak about the future round from the security perspective and possible actions to prevent DNS abuse, etc. As registrars and registries and also resellers are the part of the internet infrastructure. And speaking from the perspective of change to the, I'd say, rules like policies and the registry agreement for the new round, there were introduced some changes during the last years to the registrar and registry agreement with ICANN, which actually made the changes which you may see in the applicant guidebook and the new text of the registry agreement for the next round are not very different from how the really active registry behaves. The registry which cares about the rates of DNS abuse and bulletins, and actually it's going to be almost no difference between the behavior of a, I'd say, good and active registry. Because registers and registrars worked in a collaborative consultation group with ICANN, which helped to suggest the changes to the new 2026 round version of the base array. I underline it's just consultation. We had, as registries and registrars, we had no right to establish something. We just suggested the ways to make text, I'd say, we can cope with. Because if you put too many things you wish in the text, nobody is going to follow. Basically, some companies and organizations will just decide that, no, we cannot do that. We don't participate. And registries and registrars are not the only parties that can resolve all the DNS abuse related issues. Because the most we can do on registry and registrar level, we can block domain and to delete. And the latter is quite a bad idea, because if we delete the domain, some third party, maybe bad one, can register it in a few days, and it's not an issue. And even after deletion of the domain name from the namespace, the source of danger, like malicious files or bad content, are going to be accessible via IP addresses. And it's not curable without ISPs, internet service providers, and hosting providers. Also, some part of the issues are on ccTLDs territory. The country code TLD names, two-letter ASCII, and sometimes IDN. And a lot of depends on the particular ccTLD registry. Also, during the last year and this year, the growth of automated DNS abuse related attacks, which is done with the help of use of AI, might require interaction with the leading AI companies in order to counter and potentially directly report attacks done with the use of their platforms to law enforcement. And unfortunately, also many conversations around DNS abuse are tied to RBLs, like block lists for the bad names. And there is quite an issue with the information provided by cybersecurity companies or RBL lists, because information might be unreliable or not valid there, and RBLs are not have 100% true information, and basically have no responsibility for it and for what they send to their customers or the subscribers as danger vectors. And also, speaking about end users, registries and registrars have to comply with the agreements with their respective users. And yeah, sometimes there are resellers in between. And so also the right of user who registers domain is to have this registration service. And the registrars, registries, they have to comply with the local law, with agreements with ICANN. And it's the reason why full automation of preventive or anti-DNS abuse actions is not possible, because it's the decision of a legal nature and administrative nature, because the violation of end user agreement or registration agreement is not a good thing, because itself could constitute the breach of law. And that's why it brings with itself litigation risks. And also, most parties mentioned in my speech, except for registries and registrars and ICANN, are not part of new round policies or agreements, and basically are not bound by them. So I think we all have to continue our efforts to create better policies. And also, I want to mention that new registries are welcome into the registry constituency, and it's going to be NTAG, an interest group within registry constituency, which is going to be constituted out of applicants, so they have some kind of voice in the ICANN GNSO structure, and they later can join Contract Party House DNS abuse group, which takes care about how well things work in fighting DNS abuse. Also, it will bring possibility to participate in the joint efforts to make policies and basically contracts better for end users. That's all I wanted to share. Thank you. Do you have any questions?
Thank you, Maxim. I think so. Any kind of question we will meet in chat or near microphone. And thanks a lot for your meaningful input, and try to focus on the attention and definitely proactive abuse mitigation and transparent policy alignment with the best practices of DNS abuse fighters. There is a short, may I say, top list of expectations. So, Maxim, please go ahead.
Just wanted to notice that proactive approach is not possible, because most probably some of you can remember movie Minority Report, where the parties were punished and prosecuted before they committed the crime. And the plot was that someone just framed someone else. So the situation looked like the violation of law. So basically, in legislations all around the world, you cannot prosecute someone before they commit the crime or before they establish to be criminals, etc., etc. Because if registry or registrar think that they want to make just prosecution of false something which didn't happen, they will breach the local law, because they will breach the contract with the registrar or the contract with the registrars. And also, not many companies are going to give waivers saying that we're so eager to fight DNS abuse that we give you a waiver allowing you to delete our domain just for sake of DNS abuse. Imagine large social networks being deleted just because someone put something on the web page somewhere inside. It's not very easy choice to do. And also, we can try to predict the statistics for abuse, but we cannot prosecute before something happens. It's just illegal. Thanks.
Thank you very much, Maxim, for correcting me in my point of view. I see that we have 15 minutes for your comments, question, for the last remark or the conclusion from Frederick. So I would love to, if I may this opportunity now, I would love to thank all of our speakers tonight. So we are so lucky to have you here and have your diverse expertise and years of experience. And thank you so much for all your input provided in the most understandable and interesting way. And I may say that you guys definitely will have a lot of delightful work and joy for the upcoming months. May the force be with you. Thank you very much. And Frederick, you may take the floor, I think, or we may open the microphone for our participants.
Yeah, thank you, Natalia. Thank you, all speakers. I had one question that was posted by in the chat. I would like to rephrase and to ask, because the question is, in fact, general. There are some places in Europe where you have some regions disputed by different countries. So just take the example of Kosovo, for example. Is it part of Serbia or not? We have the same with Macedonia. They even had to change the name of their country. So what would happen here if we have a new gTLD of a region which is under dispute? I know it was already managed the previous time, and the .island, for example, could not have been registered by someone because it's an island but on two countries. What answer do we have this? Maybe from a lawyer, from Jan Janssen, or from previous experts, from, I don't know if we still have here, but just as a general question, how to manage those cases. And also the case that Maciek named with Amazon, that is the name of a region, but taken by a company, by a brand. And that's really a concern that was raised. So answers? Yes, Jan, please.
Yes, I think the .amazon issue, and I can't comment too much on that for obvious reason, but the name of the region was not Amazon, it was Amazonas. That's one thing. The rules on geographic names, if you compare this applicant guidebook compared to the 2012 applicant guidebook, they haven't changed much. And they provide for very clear rules based on ISO lists and what qualifies as a geographic name and what does not. But obviously, in disputed territories, there can be discussions. During the last round, there was an application for the Gulf Cooperation Council and also for Persian Gulf, which ultimately led to an independent review process. These accountability mechanisms are still available. But I think what is very important and what ICANN has always been looking after is to have clear rules that do not require a lot of interpretation. If something is on an ISO list or something is not on an ISO list, then there should not be much discussion about it. But the caveat there is that whenever a gag advice comes in, then ICANN needs to take that seriously. And that in the past has led to many disputes, and that dates back from the XXX case. That was the sponsored round that took place in 2006, if I'm not mistaken. So I think it's one thing of having clear rules, but then the other thing is that you will always have governments who may have their say because of disputed territories. And if the gag comes in, then it will be a balancing act, like it's always the case in legal disputes.
Thank you for your answer, Jan. So the answer is more on the side of the GAC. If I'm correct, after the string confirmation day, there is 104 days for the GAC, but also user communities and different constituencies of ICANN to have objections. It's not only the GAC, right?
Absolutely. And so if you have legal rights in a name, and then you can issue a legal rights objection. And there's also the limited public interest objections, which were used in the previous round. But I must say, if you look at those objections, not many went through. So you had the independent objector who objected to a couple of strings, but it's not because the independent objector objected that it ultimately led to a denial of the application.
Okay, that's clear. Thank you, Jan. Okay, do we have other questions in the audience? Because it's not possible to read all the chat, but if there is someone to have something to say, please raise your hand. No? Okay, so then I would like to summarize and to conclude here. So it's a new round of gTLD, but it looks simple. It's new domain name extensions. We have already many. There are some improvements from technical side, with more security. We have much more possibilities. You explained it's not only one, but now 5 or 6 different ways to have dispute name resolution. It's much more alphabet that can also raise sometimes some concerns when we have characters looks like characters in other alphabets. That will be something to manage. So that's really, this process will take years. It's not only a few months. There are good things in it, and there are also question marks. And we will see also with the different IDs. I just like very much one of the previous round is the .who's who. So you take a domain name, you add .who's who afterwards, and you have information about this domain name. I think it's really a smart way of developing new tools. It's not only to have domain names linked to something, it can really be an offer of services. There is really place to innovation with this new round, much more organized. And yeah, we will see. I hope that you all support this, and let's see what the future will is there, but for sure it's only the beginning. So we have the rules is there, but now we need to execute it. And I would like really to thank all the speakers, so also absent, the good moderation from Natalia, intervention Olivier, Jan, Martin, Maxim. Yeah, thank you everyone, and also thank to the ICANN team, also with Michel and other interpreters. So thank you very much, and have a good night. Thank you.